Why didn't they do anything about it? That's the question being asked amid mounting calls for former leaders of Dilworth School to face criminal charges in connection to years of sexual abuse. Survivors of the abuse want them held responsible. It comes after a damning independent inquiry found headmasters and boards of trustees suppressed offending and silenced victims for decades.
Welcome to another episode of We Were Children, a Dilworth School Survivors vlog. Well, we're here today with a print copy of the Dilworth Independent Inquiry report. 500 pages, which explains why hundreds of boys' lives were destroyed. Have a look at this amazing artwork on the cover. Inside the front cover, it states that the artwork was done by a former student. What it doesn't say is that student was a victim of sexual abuse who committed suicide. That really gives this report heart and soul of its own. Let's have a look at what the inquiry report says about this tragedy and how it happened and how it went on for so long.
The inquiry identified 6 major factors contributing to the abuse at the school, each of which has several sub-factors. The factors are the vulnerability of Dilworth students, disempowerment of parents, the existence of sexual abusers in staff and volunteer roles, failures in school leadership and governance, failures in school leadership alone, failures in governance alone.
Let's have a closer look at each of these factors. Cold and uncaring environment with inadequate supervision.
Former students often describe the school environment as frightening and uncaring, and some felt there was no structure for integrating new students. Students also spoke of a lack of pastoral care, which left them feeling abandoned and unsupported. Students said they felt the school environment was regimented, with many staff members being unapproachable. Students describe being punished for things out of their control, such as bedwetting and crying with homesickness. Minor transgressions or stepping out of line resulted in punishment, and until 1990, this usually involved the cane. In the Wilton era, boys who were overweight were sometimes treated in a way that caused them to be humiliated in front of their peers. In general, the harsh regime that focused on punishment silenced the students, leaving them unwilling to report serious matters, and created mistrust and resentment of school leaders. Many students reported that the inability to obtain help meant they entered a cycle of acting out and being punished. In the PAR era in particular, many students we heard from spoke of being in a continual state of fear due to the regular violence and bullying and the brutal, apparently uncaring environment, and they felt powerless to control or prevent what was happening to them. There were good staff, but opportunistic staff, or those with a sexual interest in children and young people, felt able to sexually abuse boys, aware they were not being watched or controlled by other adults.
Suffocating intensity of school life and macho, homophobic culture.
In all eras, students described critically the insular school environment. If they were unhappy, being bullied or being abused, they felt trapped. Their impression was that there was no escape and no respite. They could not go home after school. The unwritten no narking and no pimping rules that were particularly dominant in the Connolly, Parr and Wilton eras made it nearly impossible to report serious matters without repercussions from their peers. The 1984 and 1989 Department of Education circulars and an associated paper discussed in Chapter 5 provide a contemporaneous and direct insight into the level of understanding that was held within education sectors on both sexual abuse, including the impact of abuse on students' behaviour, as well as what was expected of schools in responding to it. Dilworth should have had no less of an understanding of its obligations than any other school in New Zealand at this time. Dr. Wilton, former headmaster, says he did not receive these particular circulars. However, even if he did not, information he asked for and received from Scouts in 1994 was consistent with the department's approach. It is significant that Scouts, in preparing its document, sought assistance from the department despite not being subject to its oversight. Finally, the school also received advice from its own lawyer to establish a policy or procedure for response. The board and school leadership had ample material available to enable them to understand what was required to provide a safe environment for their students, but failed to act on it.
Failure to report teachers to the Department of Education and professional regulatory entity.
While not required to notify the Department of Education or relevant teacher registration board by law before 1997, the decision not to notify them about Mr Taylor, Mr McIntosh, Mr Wynyard and Mr Cave compounded the failure not to report these individuals to the police. They all went on to teach at other schools. The school's failure to reciprocate by advising the Department of Dilworth's own unsuitable teachers, when the board had determined this was necessary information for the headmaster to obtain from the department, is inexplicable and a serious failing. In 1997, discretionary reporting of retrospective cases to the Teacher Registration Board came into effect. Dilworth took no steps to report the teachers involved in historical abuse, despite one of the now convicted offenders, Mr Wilson, having left Dilworth's employ only weeks earlier.
The inquiry received numerous accounts of caning that demonstrated an extraordinarily failure to comply with the school policy, which was based on contemporary standards.
The housemasters, particularly of the younger boys, had free rein to misuse the cane with no reprimand. Mr McIntosh had total authority and was even able to entertain his dinner guests by caning boys with their pants down in front of guests without reprimand. There was no retaliation against him when he caned every boy in the McMurray house after a food fight, in direct contravention of his seniors' instructions to give them no further punishment. Many more examples of this lack of accountability are outlined in previous chapters.
Failure to supervise staff.
There was a distinct failure by the school to supervise many of its abusing staff properly. This can be illustrated by a review of the freedom and authority given to Mr Brown by the school. Former Dilworth leaders, Mr Owen and Dr Wilton, are both long-time friends and colleagues of abusers, Mr Ian Wilson and Mr Brown. In our view, those relationships adversely affected their response to Mr Brown's concerning behaviour and Dr Wilton's response to Mr Wilson's historical abuse complaints that emerged in 1996. Mr Owen came to the same view.
Failure in board governance, Sol.
Below we discuss the specific failures that can be attributed solely to the governance of the school. They are failures to understand the business it was governing, understand the peculiar legal status of the school and need for accountability mechanisms, provide the school leadership with objective professional guidance and oversight, ensure a more effective partnership with the Anglican Church.
Neglecting child safety concerns when making disciplinary decisions.
The board has dealt with staff misconduct against students as if it was simply workplace misconduct, where termination to get rid of the problem has been a standard practice. It has overlooked the special requirements of an education setting involving children and young people and has moved the rest to other schools or institutions without warning or notice, while often not ensuring adequate care and protection for the affected students in its own school. This poor response to warnings about low staffing levels continued into the McLean era. It was not until 2008, in response to Mr McLean's report advising the board of its unease about the lack of adult supervision in the boarding houses and the risks presented by the student boarding staff ratio, that the board commissioned an external consultant to review the boarding house with a particular focus on the issue of supervision. Staffing was increased as a result of that review. This was the first professional external review of the boarding houses that the inquiry has seen in the period with which it is concerned. Having set the standards and policies, it was for the board to ensure they were applied and observed by the school leadership, particularly the headmaster, given his hands-on role within the school and his leadership position, the headmaster had an obligation to bring to the board matters of policy or principle that he felt needed board governance, or at least to be brought to the board's attention. The board should have ensured the headmaster knew what matters the board expected to be brought to its attention. These matters should have included complaints of adult student abuse of any kind, serious welfare issues such as the bullying created by overcrowding and insufficient staff, persistent rumours of sexual abuse, and the advice given by the Department of Education or the board's lawyers to ensure the board understood the gravity of these issues and concerns. Some were brought to the board's attention, but as this report sets out, there were serious deficits, either by the headmaster or the board, in taking them seriously and to take the effective action recommended. The board did not, therefore, discharge the full range of its duties of governance. The school leadership on significant issues lacked the guidance and direction it needed to manage the numerous health and welfare issues students contended with, and the necessary professional structure, such as training and managing sexual abuse, or the will to deal decisively with offending staff to the serious detriment of the students affected by their abuse. School leadership sometimes had too much autonomy to manage serious behavioural and welfare matters within the school, and was let down by governance in this regard. We note also that the board's handling of abuse complaints has been guided by the need to protect the school's reputation. This continued in 2012 and 2014, when school reputation was the driving reason for seeking suppression of the school's name, when staff member TS and Mr Dixon were prosecuted for sexual offending against Dilworth students. While the brand and reputation of the business might have been a valid primary priority in a commercial business, it should have been a lower priority when the business was the governance of a school. By obtaining name suppression for the school, an opportunity for others to come forward and report their historical abuse was delayed for a further 5 years in the case of Mr Dixon. To a large extent, the purpose for which the school was established, the charitable and forward-looking instincts of its founder, have not been fulfilled by prioritising reputation over student safety. Had the school relied all along on its main driving impetus, providing boys from disadvantaged homes with a first-class education, including care and protection as an essential part of this, it would have carved out a unique and envied reputation. The board's misguided understanding of its core business and lack of experience and expertise in school administration has resulted in other serious failings.
Lack of understanding of the school's legal status and external review.
The board's failure to understand the issues created as a result of the school's legal status as a private school and the lack of action to address the accountability gap caused by this is a factor that contributed to the abuse.
Failure to recognise weakness in the school's scholarship model.
The board failed to recognise the weakness in its scholarship model, which allowed a scholarship to be removed arbitrarily, operating effectively to expel students without a fair process and discouraging complaints from them or their parents. This policy was at odds with the evolving state school guidance, which recognised that students could act out due to abuse. Students stuck it out despite abuse rather than risk becoming a financial burden on their parents.
Conclusion.
The factors identified contributed individually and cumulatively to create an environment where physical and sexual abuse could occur and were compounding. For example, the failures of the school to investigate and report abusers or implement proper policies were compounded by the vulnerability of the students and the disempowerment of parents. Fundamentally, the failures of the school and governance resulted in preventable abuse occurring and continuing.
Let's have a look at the failure to provide counselling.
In October 1978, Mr Parr again broached the problems as he saw them at the school and asked the board to address the important issues he had raised with it many times previously. His concerns continue to focus on inadequate facilities, inadequate staffing levels and the need for professional counselling support. On Chaplain Taylor's departure, Mr Parr recommended the appointment of a professional counsellor in the place of a chaplain. Ongoing complaints about Mr. Taylor was made soon after his arrival at the school in 1976. When he was finally dismissed, the matter wasn't reported to the police, and his licence to act as a minister wasn't cancelled. He was moved into the role of Papakura Vicar. His licence wasn't cancelled until 1987, after the church discovered Mr. Taylor had engaged in further sexual misconduct with boys. Finally, there is no evidence of counselling having been provided to any of Mr. Taylor's 18 victims. The board's selection policy, resulting in a preponderance of boys from disrupted and often dysfunctional families who had serious behavioural relationship and or learning problems, the board failed to put in place the infrastructure necessary to deal with these issues, such as counselling or psychological expertise.
Current and former management reporting to the Independent Inquiry.
For the duration of the inquiry, the board's primary consultants appear to have been a psychologist with expertise in the incidence and impact of sexual abuse, a law firm led by a lawyer with a background in commercial law, and in some faith-based redress programs, 2 barristers and a public relations company. Dr. Wilton's statements that directly address the matters within the inquiry's terms of reference include a draft statement prepared by a lawyer acting on behalf of the board.
One has to ask, why was Dr. Wilton's statement prepared by a Dilworth Trust Board lawyer? And why was the Dilworth Trust Board communicating to the inquiry through a psychologist, lawyers and public relations company? This to me spells desperation to protect present and former management from any liability. Let's have a look at the laws of the day that were there to protect children.
Crimes Act 1961, Section 195, Cruelty to a Child. Everyone is liable to imprisonment for a term not exceeding 5 years, who having the custody, control or charge of any child under the age of 16 years wilfully ill-treats or neglects the child, or wilfully causes or permits the child to be ill-treated, in a manner likely to cause him unnecessary suffering, actual bodily harm, injury to health, or any mental disorder or disability.
Section 195 is not time-barred, so you can be prosecuted today for a convention that happened 50 years ago. Well, let's have a look at the statements made in the report. Then we will compare them to the law of the time. The conclusion of the inquiry stated, fundamentally, the failures of the school and governance resulted in preventable abuse occurring and continuing. So was this a contravention of Section 195, permits a child to be ill-treated? Not providing a counselling to known sexually abused students, was this a convention of Section 195, neglects a child? One has to highlight a big question. A few of the people are alive today that allowed for this criminal gross negligence that resulted in destroying hundreds of boys' lives to happen. Should they and the entity be allowed to just say sorry and move on? Or should they be held to account, punished and made an example of to demonstrate that society won't stand for gross negligence? So what is the current board's response to the report?
Kia ora, fellow old boys. Today we want to share our response to the report of the Independent Inquiry that we commissioned into historical abuse at Dilworth. The accounts in the report of abuse endured by former students, as well as the impact it continues to have on their lives, family and whānau, are distressing. The board has listened to and acknowledges what is recorded in the report. On behalf of the board, I sincerely apologise to all former students who suffered abuse while at our school, and to their families and their whānau. The Dilworth Trust Board fully accepts and is acting on all 19 of the inquiry report's recommendations.
Well, doesn't that sound sincere and caring? But do they really care? Because redress to the survivors was out of scope to the inquiry, no recommendation was made towards compensation to survivors for the criminal gross negligence perpetrated by Dilworth School. So consequently, these sincere, caring people are not offering compensation to survivors for that criminal gross negligence that resulted in hundreds of boys' lives getting destroyed. So what's criminal gross negligence worth? A jury decided compensation in a similar case recently in Australia. Let's have a look at that.
The Western Bulldogs have been hit with the biggest sex abuse payout in Australian history. The club has been ordered to pay almost $6 million to a man abused at Whitten Oval in the 1980s. His lawyers predict this case will be the first of many.
Adam Neal waited 3 decades for justice. A jury took just 1 day to deliver its bombshell verdict, declaring the Western Bulldogs failed to protect him from a pedophile.
It's been 30 years of waiting for the Bulldogs to recognise what I experienced at their club.
The Western Bulldogs now have 6 million reasons to regret their abysmal behaviour stretching right back to the early 1980s.
The club has been ordered to pay almost $6 million in damages to the sexual abuse survivor, the biggest payout of its kind in Australian history, and the first against an AFL club.
This is an enormous figure, and it's an earthquake in the legal system for sure.
The 6-person jury allocated $3.25 million for Mr Neal's pain and suffering, more than 6 times the previous record. $2.6 million was awarded for loss of earnings.
With this, I hope that it brings confidence to other survivors to come forward and find their own peace of mind.
Among the claims aired in court, lawyers say Western Oval, the club's home ground, became ground zero for the sexual abuse Mr Neal endured. It started when he was just 12 years old at the hands of Graham Hobbs, a club fundraising volunteer and convicted pedophile who introduced him to a pedophile ring. Another boy also gave evidence he was sexually abused by Graham Hobbs during the trial. Lawyers expect this will set a precedent with more compensation cases to follow.
I feel very emotional about this. I hope this sets a standard, and I applaud the jury for being so sensible and for believing a victim.
The result is likely to cause financial strife for the AFL club, which acknowledged it will need to borrow funds to pay the damages. Rochelle Brown, 7 News.
That case is comparable to some of the Dilworth School victims who were raped, drugged and exposed to a pedophile ring. So how does Dilworth compare to that $6 million settlement amount? Well, in exceptional circumstances, a survivor can get 5% of that settlement. That's right, 5%. And that's only in exceptional circumstances. Is the board reflecting what the caring, compassionate founder, James Dilworth, who bequeathed his fortune to benefit the underprivileged and a good education, do? Would James Dilworth have an independent panel decide redress with a cap? Or would James Dilworth done everything in his power to make things right and interviewed every victim personally and said, what do you need to make things right? And when the victim responded with what he needed to make things right, would James Dilworth, in charge of $1 billion business empire, have said, sorry, I can't do that, I have a cap on what I can offer you? Are the current trustees acting with the moral attributes of James Dilworth when making decisions on redress? Or is it just a business transaction? I will leave that question with you. Let's have a closer look at the recommendation 3 of the Dilworth Independent Inquiry.
Assisting recovery from historical abuse. Recommendation 3. Collaborate with survivors. We recommend that the Dilworth Trust Board consults widely and collaborates with abused former students and families in whānau of deceased former students who were or are suspected of having been abused, and works with them to identify what steps are needed to supplement the current redress program and to help them and the wider Dilworth community to heal and move forward.
Let's see what the chair of the Dilworth Trust Board, Aaron Snodgrass, has responded with about collaboration.
In accepting and acting on all 19 recommendations, the Board agrees that a respectful, two-way process of engagement is needed with all those that were affected by historical abuse at our school.
Well, I thought I would reach out to Mr. Snodgrass for a chat, so I sent him an email, inviting him to have a Zoom call with me. That was several weeks ago. He never did me the courtesy of a response to my invitation. I know the email address was correct because it was the same email address he sent me an email, which stated about the Dilworth Survivors website.
Our concern is that the use by the blog of a similar web address creates confusion in that it suggests that the blog is affiliated with Dilworth School, which it is not. This amounts to a misrepresentation that is actionable under the tort of passing off and under the Fair Trading Act. I therefore request that you cease utilising the name Dilworth School or any similar name in any way, and change the web address for the blog by the close of business on Wednesday, 26 July 2023.
This clearly demonstrates that they don't want the sexual abuse history told to prospective students and family, a sign that they're still wanting to protect the school's image from our history of sexual abuse. I wonder if they sent the same email to the Dilworth School in the US, because they look more like they are representing to be Dilworth School than I am. This is the Dilworth Survivors website. The Dilworth Legacy books were published in 2006 and cover the first 100 years of Dilworth School. These books tell a bunch of lies or half-truths about why the pedophiles left the school. They are also defamatory about the lost generation coming from bad backgrounds, which was contradicted in the Dilworth Inquiry report. This caring, compassionate Dilworth Trust Board have decided that the Dilworth Legacy books won't be revised. The current Trust Board is still wanting to cover up the history of the sexual abuse. Nothing has changed with that old school mentality. False promises of redress. This was the promise the Dilworth Trust Board Chair Aaron Snodgrass made at the Royal Commission in July 2022, when questioned why the board didn't want to wait for the inquiry report before paying redress.
But there are also a number of old boys where this had been on their mind quite intensively for a period of time, and they wanted to start putting this behind them. And so we were dealing with two groups of old boys here. And so the approach that we've taken is to get the redress program up and going so that old boys can engage with the program. The redress panel can make an offer of redress prior to the report of the Dilworth Inquiry coming out. Or the old boy can say, we wish to have the offer of redress held over until the Dilworth Inquiry report comes out. Of course, old boys have the ability to lodge a engagement with the redress program after the inquiry report comes out. So we've tried to give as many options to these old boys as we can. But what we know through the engagement that we had with old boys, that there are some that are really in need right now, and we wanted to provide assistance.
Some survivors counted on accessing redress immediately due to their circumstance, like flood relief in both New Zealand and Australia, over 80 years of age, living out of the boot of their car. These survivors have been denied access to redress because the redress panel is not ready to determine claims. Over a year later, no survivors have been paid redress, and the date redress claims might be determined is regularly changing without collaboration with survivors. The Dilworth Trust Board is now saying the decision of paying redress is up to the Independent Redress Panel. The Dilworth Trust Board should not have made false promises of when redress would be paid, thus further traumatising survivors if it was not their decision to make. The question I leave with you, is the current Dilworth Trust Board and the past Trust Boards been following the wishes, sincerity, insight and high moral standards of James Dilworth? Or are they just a business juggernaut following their own business agenda, and when dealing with the survivors of sexual abuse, it's nothing more than a commercial transaction? Thank you for watching. Please subscribe to this channel so I can let you know about the next episode.
If Isabella Dilworth was alive today, she would be